when I say in our democracy, And, you know, the example of what happens in the West Virginia election, that's actually one where they do have those other interests that they're talking about. I think they're, you know, the dissenters are wrong and the, you know, majority's right, but I at least understand what they're arguing about. You know, in Giles, it's very hard to read that case and really appreciate who Oliver Wendell Holmes is and why he has any reputation today.
I'd like to follow up on Professor Fish's recent comments on consequentialism. If we borrow Professor Neuborne's framework and we ask in those cases in which precedent, text, or purpose, spirit, don't govern, don't handcuff a judge, what is the character of consequences that is fitting or appropriate for a judge to take into consideration? In particular, I'd like to know whether it is fitting for judges to consider the character of moral beliefs that citizens cultivate, that they have in a society that we live in where the kind of racism evidenced in the Herbert Wechsler example, the kind of lack of empathy where segregation was prevalent is different than the kind of world we live in now, where the prevailing flavor of racial prejudice is implicit. And to fight that, if a judge were to embody in a decision a justification based on desire to change, to alter the moral beliefs of the citizenry in a way that, for example, they would wish to associate with those barbers, neighbors in their schools, with those unlike them, would that be fitting? Would that be appropriate? Or would that be going too far?
Yeah, I think going too far also. I think much of what we think of when we think of whether we like a judge or don't like a judge, or think a judge is what we would call a good judge or a judge we wish was substituted by someone else, depends upon the kind of consequence the judge uses. And I completely agree with Stanley. I'm talking about consequence here with a small c, systemic consequence inside the system. But I think that there's a choice. I mean, there's a whole range of choices. For example, if I were a judge, one of the consequences I might think about is effect on democracy. That might be something I would think about, and I would think that if I had to read a text one way or the other, I would tilt toward the way I think the legislature reads it. I mean, there are some judges who do that. I might think that, gee, what I really want to do is maximize individual liberty, and therefore the consequence I think about is what's going to happen to individual liberty if we go this way versus that way. That's the way I think a lot of free speech judges operate. I might even get sucked into a Rawlsian notion about economic justice and think whether or not, what are the consequences going to be here for the economic system. There are any number, I think, of legitimate, pragmatic, systemic consequences that a judge should think of. The only thing that a judge shouldn't do, and every one of the members, I think, of the current Supreme Court is guilty of doing this, is they can't tailor their consequences from case to case. You know, not have a principled view of what consequences count and what consequences don't count, depending upon whether they want to uphold or strike down an exercise of governmental power. For example, Justice Scalia, in the habeas corpus case in Boumediene, said that he believed that under those circumstances, the Guantanamo detainees had no habeas corpus, in large part because Congress had made a judgment about the relative weighing of the risks and decided that they shouldn't have habeas corpus. But then the very next case, in Heller, which is the Second Amendment case, he said he believes that the Second Amendment should be read broadly as a guarantee of individual liberty, despite the legislative determination that the guns posed a very serious problem within the District of Columbia. So from one case to another, he essentially flipped his consequences. And in one case, it was a consequence that deferred to the legislature. Another, it was a consequence that maximized individual liberty. Now, there might be a principled reason for doing that. And if he explained what that principled reason was, I would be interested to hear it. But an unprincipled moving from one consequence to another is the strongest argument I know against my position, because it allows judges to tailor-make their decisions in ways that I think are inconsistent with any notion of constraint. And I get nervous about judges who aren't honest about the consequences that they deploy.
Just getting back to the question of empathy, in an adversarial system where there are always going to be parties on both sides of the V, doesn't the issue really come down to the party with whom the judge wants to or does empathize? I mean, the case that comes to my mind is a case like Kelo, where it seems like the dissent would be characterized more with more empathy than the majority opinion.
Somebody else want to do that? Stevens has spoken to that. You know, Stevens has said that if he were a legislator, he would have voted against his position in Kelo. But he felt that as a judge, the precedent about eminent domain was such. Kelo is the case that talks about whether the government can come in and take your house. Because it's part of as part of eminent domain, because it's part of an industrial development area, and they take your house and they give it essentially to a private individual who is engaged in building a factory, and the town says, well, it's more important that we have this factory than that you have your house. And so they take the house away, pay the guy the reasonable value of the house, which of course doesn't include the sentimental notion of living in your own house. And the question is, can the government take private property for public use when the public use consists of giving it to another private person to make a profit which will benefit the community? That's a hard question, and Stevens said he thought the precedents indicated that the court had already decided that, and he was following the precedents. But he said he would have no difficulty at all with a legislature who said this is wrong and you shouldn't do it. And so it's a complicated case. Kelo is a hard case.
But I think the overall answer is I don't think it comes down to which side does the judge or the justice have more empathy with. That would clearly just be a disaster. And I think that the reason the word empathy is a difficult word is that it leads to something like that when it can be misunderstood in that way. When I say I think it is really important that the justices not be so deprived of, the knowledge of peers, it's not about who do you know better. It is that you have to know enough to be able to assess the situation that comes before you, but it's not a vote on empathy grounds. And that's the problem with the term for me. I hear the point, and I think the example of, the eminent domain case is helpful. I think there's understanding all around there, and I don't think that's the problem. I think there's understanding all around. I think there is a problem when, in fact, the issues involved address parts of our society that aren't known, or in our everyday world we ignore or have an uninformed negative image of. And then it really does matter how well someone has been exposed and has knowledge of what it is are the real issues involved. That's not a battle of, America's most empathetic. That's not what I'm asking for.
Okay, in a way, what John has just said takes us back to a quarrel that has been going on in jurisprudence since at least the beginning of the 20th century. Many of you here will know the writings of the great legal realists, and I'm thinking especially of Felix Cohen's enormously entertaining essay, Transcendental Nonsense, in which the complaint that Cohen makes, he makes many complaints, but one of the complaints he makes is that the law is continually transubstantiating the facts of real life into its own circular and stipulated vocabulary. And then on the other side, there are people, and I'm probably one of them, who would say, yeah, that's right. That's what you're supposed to do. So that is, the question here